Welcome to our 5-minute takeaway sessions presented by the Guild of Letting and Management. My name is Susie Crolla. I'm Managing Director of the Guild of Letting and Management. Welcome to today's 5-minute takeaway. In today's session, we will talk about the importance and the development within the Renters' Rights Bill, namely the proposed rules relating to the keeping of pets in the privately rented sector in England. Now, as most of you will be aware, the Renters' Rights Bill is a very complex piece of legislation and it's currently making its way through Parliament. It is designed to deliver a fairer and more secure private rented sector. And one of the most notable provisions within the bill is the formal introduction of the tenant's right to request permission to keep a pet. Under this new legal framework, tenants will have the express right to make a written request to keep a pet in their rented property. Landlords will then, under a statutory duty, consider the request and respond in writing within 28 days. Failure to respond within that period will result in the request being automatically granted by default. Now, even though the press has made a lot of noise about the fact that the bill is allowing tenants to keep pets, the right to keep pets is not absolute. Landlords will be entitled to refuse consent, but only on reasonable grounds. So what does that mean? Well, reasonableness in this context might include restrictions that have been imposed under a superior lease or licence conditions, particularly in HMOs, or genuine concerns about the suitability of the property for the type of animal in question. So some examples of reasonable refusal are as follows. There could be restrictions in the head lease. If the property is leasehold and the superior lease expressly prohibits pets, it is likely that the landlord cannot override this restriction and may reasonably refuse the request. It's important to consider licence conditions in HMO properties. Where a property is licensed as an HMO, the terms of the licence may limit or prohibit pets due to health, safety, or overcrowding concerns. Now, one of the amendments that has been put forward through committee stage of the bill relates to allergies and/or health concerns in shared accommodation. It could be that if a property is shared and a co-tenant has documented allergies to animals, the landlord may reasonably refuse consent. We've mentioned the fact that there are points in relation to HMO properties, but a non-HMO may just be unsuitable in the sense that the property does lack outdoor space, or those with limited ventilation, for example, upper floor flats without balconies or gardens, may actually be deemed inappropriate for certain animals, especially large dogs. It's also important to consider previous history of neglect or damage. Now, if a tenant has a known history of allowing pets to cause significant damage to a property or has previously breached pet-related clauses, this may be used as a genuine ground for refusal. Finally, it's important to note that there is an element in relation to pets that could cause the landlord to refuse. If the tenant proposes to keep an animal listed under the Dangerous Wild Animals Act of 1976 or another restricted breed, refusal would be considered reasonable in law. We'd like to also factor in insurance limitations. If the tenant refuses to obtain the appropriate pet damage insurance when requested under permitted terms, the landlord may justifiably refuse consent. Now, in recognition of the need to protect the landlord's interests, the government has proposed an important amendment to the Tenant Fees Act 2019. This amendment will allow landlords and agents to require tenants to obtain insurance that specifically covers damage to the property that has been caused by a pet. Importantly, this insurance requirement must be proportionate and directly related to the potential risk. Currently, there is no movement for additional deposits or administrative charges to be imposed beyond those already permitted under existing legislation. Now, as the bill makes its way through the House of Lords and committee stage, this reform signals a very clear shift in the approach in relation to pets. Blanket ban on pets, previously widespread in the private rented sector, will no longer be lawful, unless that is the landlord can demonstrate a legitimate and specific reason for refusal. Letting agents and landlords will need to adapt their policies and documentation to reflect this new legal obligation. This includes, but is not limited to, updating tenancy agreements, introducing procedures for reviewing pet requests, and ensuring compliance with the revised rules on fees and insurance. Ultimately, it is very clear that this element of the Renters' Rights Bill aims to support responsible pet ownership, whilst also balancing the rights of landlords to protect their properties. It's part of a wider movement to make renting a home for tenants more secure and a more humane experience, recognising that for many individuals and families, pets are a vital part of daily life. Thank you for listening to today's session. For further information on the services we offer, head over to our website and subscribe to our channel. I look forward to seeing you next time.